Thank you very much for this conference that has been really interesting so far, and for giving me also the opportunity to present my ideas to you today. I'm working at Technische Universität Berlin at the Institute of Architecture in a chair called Habitat Unit as a postdoctoral researcher. And last year I finished my PhD in sociology on informal housing in London, also at TU Berlin. And today I'm going to talk about the theoretical approach to informality, illegality, and regulation that I developed in the last years. And I will illustrate it with a few examples from my case study on informal housing in London. And I'm going to read this out so that I don't get entangled in details. And I'm a bit short of breath these days, so apologies for that. How do I? Well, okay, so my starting point for thinking about urban informality is a context of social need and struggle. And the key question in this is who can do what to whom? How do people rein each other in? And what mechanisms of regulation have they found? And what are the stakes around which this revolves? Because someone building a house cannot build it as big as they want, and someone letting to a tenant cannot be as mean to their tenant as they want. And even though most cities and states have legal requirements, upon closer inspection, and especially if you consider the insights from the urban informality debate, we see that laws often play less of a role than we might wish or assume. And I would even say that most laws appear to not really matter until there is a conflict. So accordingly, we might ask, under which conditions do laws attain relevance? And under which conditions do actors draw on them and use them to which effect? So, sorry, this is too fast. So in my approach, I adopt the notion of laws and other formal rules as codified prescriptions for how to do things. And as such, they are just sequences of words in my thinking. So they may become powerful tools to structure how people relate to each other, but they may also be of rather limited relevance for that. The advantage of framing formal rules as codified prescriptions lies in that it emphasizes that these codified prescriptions need to be used to be of any relevance. They need to be interpreted and drawn on. The meaning that codified prescriptions are given may vary and change, and just as much do the possibilities of their usage in the negotiation of power relations. So the questions that this perspective thus carries include: how are formal rules used and how are they made relevant? And what possibilities do people have and use, like which do they make use of to make laws relevant? And I ask scholars of urban informality not to get entangled into trying to distinguish what's legal and what's not, but instead to ask what are the conditions under which specific understandings of laws and legality are created and what is their effect. For today, I have two propositions. The first is that the meaning of laws is socially constructed and an object of negotiation among the actors involved. If we think of them as sequences of words, the meaning of these constellations of words can obviously vary. Barbara Edelman and colleagues call this the endogenization of the law. It's the process by which a common sense of an interpretation of legal sentences is socially constructed over time by a range of actors, simply by them negotiating the meaning in their interaction, such as through disputes. And for an example from London, I was able to have detailed exchange with officers from two boroughs on their enforcement strategies against what is known as sheds with beds and rogue landlords. Sheds with beds refers to second buildings on properties that in the public discourse are generally known as quite unacceptable. However, if you look at them a bit closer, you see that Neither their illegality nor the bad housing quality is as clear-cut as it is portrayed in the media and by the government. The other spatial forms of housing that are frequently, but again, not always, found in conjunction with a really low quality and fraught with a variety of insecurity and health hazards for the tenants include internal conversions by putting in more walls, basement conversions, garage conversions, and extensions. And all of this takes place behind inconspicuous facades, as you see them here. So overall, there is a similarity to what we heard yesterday for New South Wales. And generally, if these kind of housing issues are brought to court by the enforcement officers, the judges responsible for these questions are lay judges, so they are not trained. Looking at these two boroughs, we can find that there's a generalizable difference among these respective lay judges and what they know about inadequate housing and in how they judge its tolerability or intolerability, and accordingly in how they decide about fines and penalties. And corresponding to this difference, the enforcement teams develop different strategies to convince the judges of the severity of the housing problems. And one team is more successful in this than the other. And as a part of this, I observed that in these two comparable settings of interactions among lay judges, enforcement officers, landlords, a term that I have to use for lack of a more gender-neutral term, and tenants, different interpretations of the same laws emerged. So let me give you two examples on this. The comparatively unsuccessful team told me that they do not often issue prohibition orders on outhouses. That is, orders that the use of the property is prohibited. Because in their understanding of the law, they can be subjected to pay compensation for the loss of income by that property owner who is prohibited to use the outhouse as a residential unit. In contrast, in the comparatively successful team, they thought, I will read this out, it's also on the slide, if it is an illegal shed, we took the view that no, because it is illegal and it is not a dwelling that should be there anyway, we would not be required to pay the compensation. If you do it for a regular normal house dwelling, then yes, you may have to pay compensation. Then I asked, okay, so it would only be in the case where planning is fine that the local authority would have to pay compensation? And he said, yes, I think so. It's a bit of a murky area, which, laughing, we are all grappling with. It's an old piece of legislation, really, that went back to the days of slum clearance, whereby the council would go in. It's not criminal landlords, they were just areas of slums. And the council would either demolish the property or close it. And then the landlord lost their income, so we had to pay compensation. But these are not regular dwellings, they are sheds. So, as you see overall here, in the one borough, they were afraid of being made to pay compensation, and in the other, they weren't, because they interpreted the same law differently. The second example is even stronger in showing that endogenization among officers happens through the interaction with the other actors. In the experience of the comparatively unsuccessful team, landlords are able to successfully claim in court that they did not know about the number of people actually living in their property. The landlords would argue that they had issued only one tenancy agreement to one tenant as opposed to one agreement each to all tenants or households. They would then argue that the main tenant must have sublet the property. For the officers then, it was difficult to prove in court beyond reasonable doubt that the landlords knew what was going on. In the comparatively successful team, in contrast, they were quite firm in their position that the landlords are expected to know what is going on in their property and that they can be held accountable for it. Indeed, they, in this borough, it's the courts who, quote, will not swallow it, basically. Their view is that the landlord is the landlord. They have to control the property. and they should make sure they are aware of what's going on within their property, unquote. So this example is about the obligations of landlords and how in one setting, judges and enforcement teams saw landlords obliged to be informed, and in the other, landlords could portray themselves as the victims of the tenants in this case. So these different interpretations of the law in the two distant parts of London come from different negotiations among the actors, and they lead to a different confidence among the different people involved with respect to their abilities and to their action possibilities. So that doesn't only refer to the enforcement officers, but also to the landlords who adapt their strategizing in turn. So as a sort of interim conclusion, my move of framing laws as codified prescriptions with variable, negotiable, and manipulatable meanings puts a specific and potentially helpful light onto the question of legality, because it implies that the judgment of practices being compliant with a given law or not change accordingly. The same law may be used to frame similar actions as legal in one situation and as illegal in another. By framing laws as codified prescriptions, analytical attention comes to rest on the conditions and on the processes of the construction of legality, rather than on the potentially non-compliant action and the question of its legality itself. My second proposition is that laws and other formal rules may have an impact not only in terms of their literal text, but also in how they are being used by people to negotiate their relations to others, and thus how they are used to negotiate what they can do to others and what can be done to them. Turning back to the case of London, when inspecting properties, enforcement officers cannot simply make surprise visits. They can do so only if they have a warrant. In all other cases, enforcement needs to give a written 24-hour notice of the visit. Landlords who know what the enforcement is looking for use these 24 hours to take certain measures. They evict or displace the tenants, they take out the bed, other items of dwelling, and the personal belongings of the tenants, and they sometimes even rip out the installations. And then instead they put in other material objects such as gym equipment or storage stuff. So in effect, quote, they make it look like it's not lived in, unquote. Yet, importantly, as another officer told me, quote, experienced officers will always be able to tell how a property is being used, unquote. So here we can understand the situation, this legal situation, as more favorable to property owners than to public enforcement. And often enough, it's not about the knowledge of the enforcement officers of what's going on, but about their ability to prove it. And the landlords use this formal provision of 24 hours to their advantage, and thus they play with the officers who are knowing but helpless. Turning to my conceptualization of informal rules and regulation, as I've shown, formal rules and laws are key to the negotiation of power relations, but they are not necessarily so in the way typically assumed and theorized. Their relevance is not given per se, but it depends on social praxis, on how they are commonly used. And I grasp this notion of common ways of doing things as informal rules. Thus, formal rules refers to codified prescriptions, to sequences of words, and informal rules refers to common ways of doing things. In sociology, it's a basic idea that in how we do things, we follow rules. And most of the time, the rules structuring our everyday life are implicit rules, they are social rules. They are not written down. And indeed, we can think about any attempt of writing rules down as taking them again out of the realm of being applied in practice. And if we breach these social rules of everyday life, we also receive sanctions by others, just as with some of the formal rules. And even though formal rules such as laws are much more visible, that doesn't mean that the non-formal rules may not be much more relevant for our everyday life. And in this sense, the term social regulation means something different from the usage of the term regulation that is common both in colloquial speech as well as in the urban informality debate. In the urban informality debate, the term regulation is used to refer to the set of state rules as in state regulation. But with the theoretical toolkit that I draw on, I lost a page, sorry. I am explicitly departing from this view, and I conceptually embrace the idea of social regulation in which formal or legal regulation plays a part by being used as an instrument of power, but formal rules and laws never completely regulate, even if they represent an attempt at doing so. And so finally, the key messages of my talk today are first, that laws and other formal rules only become relevant and meaningful through social practices, only by being actively drawn on. The second is that when we're interested in the legality of certain urban practices and conditions, I suggest not to aim for identifying anything as legal or illegal, but to research the conditions under which understandings and judgments of these practices or build structures as legal or illegal have locally emerged. And this locally means also in relation to other places in the world, depending on the people involved, really. It's people specific. And the third is that the same applies to informality. Instead of identifying specific settlements or houses or market spaces or vending activities as informal, I suggest researching why others frame them as informal and what consequences result from this calling them informal. Because in the end, I think that the labels informal and formal are very powerful. They carry strong and risky implications for the people involved. And as researchers, I think that we should be very careful in how we contribute to the negotiation of power relations by using these terms. And even though this may seem as if I wanted to depart from speaking of urban informality at all, that's not the case. And instead, I suggest speaking instead of informal settlements, to use the term urban informality to refer to the contemporary phenomenon of the inadequate provisioning of urban goods to people in need. And this appears to be a systemic feature of the production of cities today. So in my suggestion, it's really about inadequacy, and as such, it's a phenomenon. And I also understand the meaning of inadequacy just as the meaning of legality or illegality to be socially constructed and negotiated. It's not for me to define or for us researchers, but it's something that takes place in the case, in the field. And for us, it's the task to understand when this is the case. Exactly. Thank you for your attention.